sure you have your cell phone on silence. All rise. Hear ye. Court of Appeals of the First District of Kentucky, now in session. Pursuant to majority of our state constitution and this honorable court.
Please be seated. Good afternoon. Welcome to the First Court of Appeals. We have one case in the docket this afternoon is 01-23-00629, POOLRE Insurance Corporation versus Stewart A. Feldman. Starting with appellant, counsel, will you please make your announcements?
Ben Foster on behalf of the appellant, POOLRE Insurance Corporation.
Thank you.
John Gorman representing Stewart Feldman and the Feldman Law Firm. Rafi Malconian represents the Capstone parties and Feldman parties. I can answer any questions about Capstone that the court has.
Very good. Thank you, Mr. Gorman. Each side will have 20 minutes for argument. Does the appellant wish to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes.
Very well. Okay, appellant will reserve 5 minutes for rebuttal. Before we begin, I think you know the drill. When the light turns yellow, that means you have 1 minute left. And of course, red means stop, but if you're in the middle of answering your question, please feel free to finish your answer. I know this case has a very complex background, and we've tried to do our very best to understand at least the issues that are relevant, or the backgrounds that are relevant to the issues that we're disputing here today or analyzing. We don't need to have a full recitation of the facts. We've read the briefs very carefully. We appreciate your advocacy in trying to get us to understand the very complex issues here. I think it would be most helpful to us if you can just dive in right into the legal issues that we have to decide here on the confirmation of the arbitration award. We are now ready to proceed with the count.
May I approach?
You may.
Good afternoon, and may it please the court. I want to start by saying something really basic. Court orders belong to somebody. When you have a dispute, normal lawsuit, a plaintiff brings a case. If they prevail, they get a judgment. That judgment, say it's for $100,000. It belongs to that plaintiff. The right to enforce that judgment is that plaintiff's right. The rule is the same if it's an injunction. An injunction belongs to the plaintiff who received it. The rule is the same for declaratory judgment. So, the core legal issue in this case, cutting through a lot of complexity, both substantive and procedural, is whether the Federal Arbitration Act or the Texas Arbitration Act confer jurisdiction on a court to confirm an arbitration award independent of whether the litigant can satisfy the basic constitutional requirements of standing and subject matter jurisdiction.
Well, let's start there, right? Because there are different issues here. We have subject matter jurisdiction regardless under the FAA and TAA. Do you dispute that the district court here had subject matter jurisdiction to consider the confirmation of an award period under the TAA and FFA, which seems implicit based on the express terms of those two statutory provisions?
Sure. So I do dispute that the TAA and the FAA are capable of conferring jurisdiction. Obviously, the trial court is a court of general jurisdiction,
Correct.
and we'll talk about that in a second. But the FAA and the TAA do not confer jurisdiction. They are non-jurisdictional statutes.
And why do you, I understand that there's a lot of federal cases that state that the FAA does not confer subject matter jurisdiction, but that's in the context of federal courts which have limited jurisdiction, as you know, either diversity or federal question. So in that way, they cannot confer or create jurisdiction. But when you have courts of general jurisdiction, the FAA and TAA expressly state that a district court has the power, and i.e. the jurisdiction, to confirm an award.
Yeah, so my first answer to that question is the Texas Supreme Court's holding in the Hall Street case, which is cited in our briefing, where in Hall Street, the court just says, like the FAA, the TAA is non-jurisdictional. That is what the court says. Now, the issue in that case is not similar to the issue in this case, but you'll probably hear me say that a bunch of times today, because I don't think any of the cases have an issue that looks very much like this issue. But that is the court's holding. Now, second of all, the cases that are closest, I suppose, to the facts of this case also don't just say, oh, there's a dispute about confirmation, therefore we have jurisdiction. So that would be the 14th Court of Appeals, Cook versus Thomas, right? Where it doesn't make a lot of sense. If it's just, I want to confirm an arbitration award, therefore I have standing, the 2 or 3 pages of the 14th Court's analysis of whether there's standing in that case.
I don't disagree with you. I'm just separating mootness, ripeness, standing separate from general subject matter jurisdiction.
Okay, so with that clarification, I think this is the court of general jurisdiction. I think the question is whether they have standing to confirm the award.
Okay, so guide us through that analysis.
Yes. So here's the most basic problem with standing. The history of this case is very complicated, but at no point in time have any of the appellees in this case ever asserted any causes of action against the appellants, or have any of the appellants asserted any causes of action against the appellees. We were allied litigants in the arbitration, represented by the same counsel with no cross claims between the parties, right? So there was no dispute between us. Obviously, we had a dispute with the St. Charles parties, the adversaries in that case, and the result in the Glasgow arbitration is that the St. Charles parties win. Not completely, but they win in part. And the St. Charles parties received monetary damages against the appellees, and they received declaratory judgment against POOLRE and the appellees, right? So the basic point is whose declaratory relief is that? And the answer to that question is
Isn't that a question? And this is where we need your help, because you hit it on the nail when you started and you said the right to enforce a judgment belongs to the claimant. I don't disagree with that, but I do think there's a distinction between enforcement of a judgment and confirmation of an award. So whether or not the FELDMAN entities would be able to enforce a confirmed award against POOLRE is not an inquiry that we need to determine. The question is, can they confirm the award? So why, and I got a little lost on that, so I think it would be helpful, because I'm not following why confirmation alone would have to be tied to adversity of the parties.
So I can talk through the argument from the statute about why I think the statute say that only an adverse party can confirm an award. I think it's explained adequately in my briefing, but to say it in 5 seconds, the requirement in both the TAA and the FAA is that when you file to confirm an award, you file to confirm it against the adverse party.
Where does it say that? Because I don't see that language in section 9 of the FFA. And I follow the argument that was made in the brief, but section 9 has 2 different provisions, right? And so the adverse party provision concerns only service of the application for confirmation on, quote, an adverse party.
Right, and so our point on this is, if the only person you're allowed under the FAA to serve your application to confirm on is an adverse party, then you have to be adverse to the party you're seeking to confirm the award against for the step of service, which is a prerequisite to being able to do the entire confirmation flight.
So wouldn't we then be required to read some language into section 9? And I don't want to put you at a fair disadvantage. I don't know if you have it in front of you or not. Okay. So the very first sentence is, if the parties in their agreement have agreed that a judgment of the court shall be entered upon the award made pursuant to the arbitration, and then you skip ahead, says any party to the arbitration may apply to the court so specified for an order confirming the award. It doesn't say an adverse party.
Right, but to say how, it says notice of the application shall be served upon the adverse party, a little bit lower in section 9.
Right. Some courts have construed that to mean that adverse party means just the party that has been named adversely in the application, right, not in the arbitration. How do we distinguish those cases?
I think that the authority that so holds is not controlling on this court. I don't think it's a question of distinguishing. But let me say this, because I want to make sure I'm really clear about this. I think the statutory analysis comes second, because I think the first question is whether they can meet the case and controversy requirement.
That's fair.
Right?
Walk us through that.
And so, okay. I mean, that's the analysis in Thomas versus Cook, and it's also the analysis in the Third Circuit case, Teamsters Local 177, right? In both those cases, the court's confronted with the question of whether it can confirm an award in somewhat unusual circumstances, and in both cases, it walks through whether there is a real dispute between the parties, not just a dispute over whether the award should be confirmed. So the problem here is there is not a legally recognized dispute between POOLRE and the FELDMAN parties, because there is no cause of action, and there never has been. And so, you know, what's the dispute? In Teamsters Local, right, the Teamsters say we need to get the injunction enforced so that we can stop UPS if they violate it down the road. And the court says, okay, right, that's the last step in you getting the relief you went to arbitration for. And the same thing's true in Cook versus Thomas. They sort of reject the procedural games that the plaintiff in that case played, and they say, well, there's a monetary judgment against the plaintiff on the counterclaim, so we need to enforce that. We need to bring it into the world in an instrumental way that's going to make it mean something. But we don't have that scenario here because there was never a claim. The FELDMAN parties never asked POOLRE to do anything or to refrain from doing anything at any point in time.
Why doesn't that then tie us back to the adverse party? And this is where I lose the chain of the link here, is again, you don't have to be adverse, right, under the provision of the FAA to seek confirmation. And I realize this is an unusual procedural thing. You're right, I haven't found a case like this. It's very unusual. So what is a party to do here when you don't have the winning claimant seeking confirmation? Are they without any recourse at all?
But this is the point, right? What is the recourse that they want? They have no recourse. The court said it a minute earlier, the question of confirmation is a distinct question from whether they could do anything with the judgment once they have it. But there has to be some practical consequence of the court's decision today. And if the FELDMAN parties don't have the right to do anything with the judgment once it's entered, and the party who would have the right to confirm, the St. Charles party, has elected not to for whatever reason, then we're having we're about to enter a hypothetical order. We're about to enter an order that nobody has standing, nobody has the authority to do anything with. It doesn't instrumentalize the end of the arbitration like a confirmation of money damages would. It's just a piece of paper, right? And in the brief, in their response brief, what Feldman argues is that they in fact do have the right to enforce the declaratory judgment, which they repeatedly call an injunction in their briefing, against POOLRE. That's what they say. So they're very clear about what their motive is here.
Man, we don't have to decide that though. We don't get to decide whether they can or not. That's going to be a question for another day for another court to decide.
But my point is that the case and controversy requirement is supposed to avoid hypothetical determinations. There's supposed to be a concrete injury in fact. That is part of standing. That POOLRE, or that the Feldman parties has suffered, and they're coming to court to get it redressed. And that's what's lacking here, because they don't have a concrete injury in fact, because they don't have a claim. And so that's why I think the case and controversy is a prerequisite. You have to satisfy that before answering the question of whether the TAA and the FAA, under their statutory framework, gives this particular party the right to try to confirm the award. Because any party in any context that wants to get into court has to be able to have standing to bring the proceeding in the first place.
How would you distinguish Teamsters in the language where the Court of Appeals stated that there is a live controversy that stems from the arbitration itself? And I understand the point you're making very clear, that these parties were not adverse, so there's really no controversy between them. But are we to look at the arbitration proceeding as a whole, as opposed to sectionalize it on a claim-by-claim analysis?
So I don't think, so I want to say this first. I think in Teamsters, to try to directly answer your question, obviously the way I'm going to distinguish Teamsters is I'm going to tell you the injunction is the Teamsters injunction, right? What's motivating the court in that case, what the court basically says is it says, well, if I don't enter the injunction, then they're going to have a whole new legal proceeding if they want to try to enforce it, right? But that analysis, that rationale breaks down here, because if the district court doesn't confirm the award, or if the district court does confirm the award, nothing happens, because they're not the party withstanding to enforce the award. They can't go back and do anything with it. And so that's the primary distinction between this case and the Teamsters case. I recognize that the court, which is not, in the court in that case, which is not confronted with the weird issue we're confronted with here today, doesn't grapple with this at all, because they don't have to, right? But what I would say is, and I think I put this hypothetical in my reply, imagine that the Teamsters had filed against FedEx and UPS, right? And they won against both. And then for whatever reason, the Teamsters had decided not to confirm against UPS. Are we really to think that FedEx can come in and say, for whatever reason, oh, I want to confirm the award against UPS, regardless of whether the Teamsters have reached a resolution with UPS, there's a new collective bargaining agreement, whatever might be going on in the background that makes the party that has the right not want to do it, right? And what you get, you know, the Third Circuit in that case, it distinguishes itself from, you know, Derwin versus General Dynamics, the older First Circuit case that came out the other way.
Right.
And you know what the First Circuit says in that case is we're not in the business of entering orders that don't mean anything. And the Third Circuit doesn't disagree with that, not directly. What the Third Circuit says is, well, this order clearly means something, and so did that one, right? But the basic premise that the court is not in the business of signing pieces of paper that are meaningless. I mean, that's where the fundamental questions of case and controversy, the basics of standing and subject matter jurisdiction come from, is the idea that if I am a party and I want to access the court, I have to have a dispute with the party I am bringing to court. I mean, that is fundamental to the entire idea of, frankly, the common law, right? I mean, that's what it means. It's not, again, as I said at the very beginning, it's not that the order has some independent life of its own, except for to resolve the dispute between the parties who ask the court to do it. And so I think that's the problem here. I mean, I've said it, you know, a couple of times now, so I won't belabor the point, right? But, you know, when you look at the arbitrator's final award, when you look at what he says, I think it's CR 421, he specifically says that the declaratory judgment is the St. Charles parties, right? It says the declaratory judgment is granted, and I'll get the exact language here,
What record site are you looking at, do you know?
CR 421.
Okay, I'm there with you.
Give me 1 second and I'll be there too. Right, it's further, this is in the middle of the page, it's further ordered, adjudicated, and decreed that there is hereby entered a declaratory judgment in favor of respondents.
Right.
And then there's a long definition of who the respondents are, but it's the St. Charles parties, right? And that declaratory judgment is against these appellees and POOLRE. So it's just, and then it goes on at the very end, right? It's the Mother Hubbard clause, all other relief is denied, all of the claims not addressed by POOLRE and Feldman are denied. So it is a fact, right, that Feldman, and they say this in their brief, that POOLRE and Feldman both did have declaratory judgment claims in the arbitration. Those claims weren't against each other and were denied, so they're not an issue.
Do you have any questions? Just so before I let you go, just to summarize, is it a fair summarization of your argument to say that if, in order to have a case or controversy to confirm an award, your argument would be that there has to be some level of adversity between the parties as to the original arbitration?
That's right, because constitutional standing requires an injury in fact by the party asserting it that the court is capable of redressing. I mean, that's not the entire doctrine, right? But that's kind of the core of it, and that isn't present here.
Okay, thank you. Mr. Gorman, we're ready to hear from Appellee.
Good afternoon, may it please the court. I'm going to pick up with the issue of injury in fact. And the Third Circuit, in the Teamsters Local 177 versus UPS case, addresses this very issue. Confirming an award under Section 9 is not to be confused with litigating a dispute over the validity or accuracy of that award under Section 10 or Section 11, or seeking later to enforce the arbitration award where there is non-compliance. So making that distinction. Section 9 expressly provides for confirmation in the absence of such disputes. So what the Third Circuit is saying is that a party to an arbitration suffers an injury when he is denied the right to obtain confirmation, for it is the judgment that makes the party whole and concludes the arbitration process. So we don't have the constitutional standing requirements that normally attach to litigation at the outset of the case, where a party comes into court, has to show an injury, in fact, he's aggrieved, the court can redress the injury. We're at the end of the process here. We've already gone through the arbitration where standing may have been an issue at the beginning, but the arbitrator would have been able to decide that issue, and he did. He decided declaratory judgments that all parties submitted to it. And when I say that, we have the Fourth Amendment arbitration demand that POOLRE and the Feldman Capstone party submitted, and we have a claim for declaratory relief that the St. Charles party submitted they did so in the Medley arbitration and the Gill-Jefferson arbitration, but that got dumped into the Glasser arbitration. So there were cross claims for declaratory relief. And in Texas, when you have, and Texas substantive law applied in the Glasser arbitration, in Texas, when you have a claim for declaratory relief, the Declaratory Judgment Act in section 37.006 requires joinder of all parties that have an interest in the outcome of the dispute. And here it was interpreting specific agreements. Those agreements included not just the joint engagement letter from 2015, but all these stop loss reinsurance agreements and quota share reinsurance policies.
But let me ask you, because I want to make sure I understand. When I looked at the judgment, though, I don't disagree, and of course I don't know the entirety of what was disputed in the arbitration, but whether or not those issues were presented, the actual relief that was awarded as to POOLRE was only declaratory relief in terms of their ability to use the risk fund pool for certain purposes. So that, despite all of these issues that might have been litigated, that was in fact the only relief that was awarded as to POOLRE. And so how do you address the concern that there is really no adversity between the FELDMAN entities and POOLRE? And in Mr. Foster's defense, well, I read Teamster, I don't disagree with the statements of Teamster, but there is this distinction that there was an adversity between those two parties. Those were the two parties to the arbitration. This is a very unusual situation that we have here procedurally.
Right, and I don't want to confuse the court by saying the Declaratory Judgments Act is a substantive rule of law in Texas.
Right.
It's procedural. But having said that, I think it's 37.003 provides for affirmative relief when a court or an arbitrator grants a declaration, and negative relief. So when you look at Glasser's award, and he says that it's further ordered the judge to decree that there is hereby entered a declaratory judgment in favor of the St. Charles parties, he goes on to say that it's declaring that Feldman and those in active concert with him, including all related entities, capstone companies and POOLRE, cannot tender to the risk pool. And then he goes on and
Right.
the two main things are you can't use risk pool funds to pay legal fees, and you can't use risk pool funds to pay claims submitted by Amy, which is the captive insurer for the Feldman parties and the capstone parties. So that is the negative side of Glasser's declaratory judgment that fits in with exactly what the Declaratory Judgments Act says in 37.003. So we have a positive side. It's like a yin and yang. We have a positive side to the declaratory relief, and we have a negative side. And the Declaratory Judgment Act provides for exactly that. So you can't just look at it and say, oh, well, the St. Charles parties won, so they're the only ones involved. The Feldman capstone parties lost, as did POOLRE, and it was a negative declaratory judgment.
Maybe I'm not following you on that. The implication being what? That it was a negative in the sense that, then what? I mean, the issue remains that there's no adverse, at least if we follow the argument, because I want to make sure that I get your response to the argument. The fact that the Feldman parties and POOLRE were aligned, and there was no cross claims filed against each other, and there's no adversity. And whether there's affirmative or negative relief awarded, it was still in favor of the doctor group, right, of the claimants. And so the point here by Mr. Foster and the appellant is because there's no adversity, and I'm not saying I agree with the argument, but I want to give you the opportunity to address it, because there was no real adversity below in the arbitration. There's this rule that non-adverse parties cannot seek to confirm arbitrations as to each other. So can you help us understand why is that wrong?
Sure. Let me give you one example that I think is very concrete and easy to understand on this adverse party issue. When you take a look at FAA Section 9, it says any party to the arbitration can seek to confirm the award. There is no conditional language there. There's no injury requirement. There's no redress requirement. Nothing like that would make up normal standing concepts in litigation, because, like I said, you were at the end of the arbitration process. Now, jump to the beginning of the arbitration process, and let's take a look at FAA Section 4, which governs a motion to compel arbitration. And in that section, Congress inserted an entry in fact requirement. So Section 4 says a party aggrieved by another party's refusal to arbitrate
Right.
can petition the court to compel arbitration. So that is right there in the statute, creating an adversity requirement, unlike Section 9 that lacks it. So right within the FAA framework itself, there is that distinction, and we all know the rules for statutory construction provide that when Congress or the legislature puts a requirement in one section of the statute and leaves it out of another, then that's intentional. And court can't imply that requirement that's been left out into the statute that omits it.
Well, isn't there still the background constitutional requirement for a case, for a judicial case or controversy between the parties, regardless of what the statute says?
Well, and I looked at that in terms of the case law, that where the UPS case gets into a fight with the Second Circuit and some other circuits, and it's really at the tail end when you go in to confirm an award and the losing party decides, I don't want to go through all this rigmarole, I'm just going to pay the thing off. I don't want writs of execution coming at me, garnishment, or whatever else. So they pay the award off. At that point, a standing or justiciability issue arises, or mootness, because what is there left to enforce? What relief can the court grant? And that's none.
Well, what is the point here? Because that was the argument Mr. Foster said. What's the consequence? What is there left?
Right, and that's why
When you get your confirmation of an award, then what?
Right. So the issue here is the pool. The St. Charles parties weren't the only ones that paid money into the pool. Everyone who was a captive insurance company paid money into the pool, and that included the captive insurance company for the Feldman Capstone parties, and that's A&E Property and Casualty. And you can look at the stop-loss agreements in the record of quota share, and there's an attachment, has A&E as the very first captive insurer. So there's money coming from A&E's insurance to A&E, so the insureds are indirectly paying into the pool. A&E takes that money and pays it to POOLRE to get reinsurance on its claims that it pays. So there's a live stake for the Feldman Capstone parties in seeing that the pool money is spent correctly.
But you have those claims regardless, right? Why would the confirmation of an award be detrimental or helpful to that claim?
Well, the confirmation is the only way to enforce the award, because Glasser's award is not self-executing. And it has to be enforced as written by the arbitrator. And only a court can grant a judgment that would lead to an enforceable, or confirm the award that will lead to an enforceable judgment, and thereby let the court use all the tools at its disposal to enforce the judgment. There is no other way to enforce it. The arbitrator can't do so himself.
So the argument would be you want to confer the award so then you can then enforce the award and have POOLRE replenish that amount of money that they took from the pool risk pool?
Well, I haven't gotten that far. We're just trying to get it confirmed.
Right.
But, and that's why I read that part to start from the UPS case, is it says enforcement is a down the road
And
issue.
I agree with you that there is a
And
very
yes, you
clear
brought that up.
distinction between enforcement and I agree with you on that. I was just trying to, in our minds, we're trying to figure this out because it is unusual to have a losing party seek to enforce, confirm an arbitration award, and then to do so against a counterparty that they were not adverse to. It is an unusual situation, so really appreciate you, both of you, walking us through the issue. I was just trying to get to this question, like, so what? There is no adversity. Are we really rendering an advisory opinion by, not an opinion, but we're confirming this award that is really moot, I guess, in some respects, or not enforceable. And I think that was Mr. Foster's point, like, so what? What is the consequence of this confirmation if, in fact, there are no claims between the two clients?
Right, and it turned out with the way the declaratory relief, POOLRE's counsel here today was not counsel at the arbitration. So the way the arbitration proceeded is that you could tell that POOLRE had an obligation to the pool. We were a we were captive insured, so we had a vested interest in the pool money ourselves. And we were aligned during the arbitration, but like I said, all parties submitted the issues about how do you spend the pool money? Is it authorized by the quota share agreement for POOLRE to take pool money and spend it on legal fees? Everyone briefed that issue. And so it wasn't, like Your Honor said, it wasn't a compartmentalized take on arbitration or the issues on arbitration. It affected everything globally in the arbitration because of the way all the claims were alleged. It all had to do with the money. Didn't really have to do with, representing, people on, was it a good, captive insurance policy or anything like that, like you usually get in insurance cases. Does an exclusion apply? It wasn't anything like it. It was like, follow the money. Where did the money go? Why did it go there? So everybody had an interest in the money. And that interest continues to this day. Because as POOLRE has admitted in its briefing, and I believe at the hearing, that the more POOLRE's counsel comes into court, the more POOLRE has to draw on the reinsurance risk pool to pay legal fees. And so while POOLRE places the blame on us for doing that, that is in direct violation of the Glasser Award that says, do not do so. And a few days after this award issued, POOLRE paid its arbitration counsel $2 million. And we have the wiring instructions that we got in discovery since the briefing that established that. So when we saw the extent of it, now we're really interested because $2 million came out of the pool. And part of that money was put in there by us. So when money goes into the pool, it's not like it goes into individual trust accounts for each captive insurance group. It just goes into one bank account. So that money's all commingled. There's no traceable accounting.
So assuming this is an injury that your client has suffered here, that injury is not addressed by the judgment, or the award, in its final terms, am I correct? Because it doesn't resolve any disputes between these two parties.
Well, not directly, but it does say that POOLRE cannot spend risk pool monies on legal fees and expenses incurred in the 2020 arbitration, any of them, all 5, and any future directly related proceedings in state or federal court. This is a directly related proceeding to the arbitration because it's a proceeding to confirm the award.
Right, and so there was the award and then some outside settlement of the award prior to confirmation. And so the party to whom the relief was awarded in the judgment isn't terribly interested in these aspects at this time. But you like that. This is a very tenuous connection to me.
Well, I liken this to a 3-legged stool. Mm-hmm. So you had the St. Charles parties, you had POOLRE, you had us. Okay? With 3 legs, you can sit on the stool. You take 2 of the legs out, St. Charles and POOLRE, leaving our leg, and the stool becomes unstable. But we're still there as that leg. That leg has not gone away. We were not a party to that settlement agreement, and that settlement agreement and release can't bind us. And in Texas, there's a very strict rule on settlements that the settlement only releases the party's name to the contract. And the way this came about is that we moved in federal court to dismiss the case because the St. Charles parties had moved to confirm the Jones Award, and the Jones Award granted relief against POOLRE. And so they submitted the St. Charles party submitted a proposed judgment that included relief as to POOLRE. And it looked to us like POOLRE's all of a sudden in the case. So we moved to dismiss because POOLRE is not diverse. And there's no federal question, just to make things more complicated.
Yeah, exactly.
So POOLRE is a Delaware corporation, principal place of business in Texas. We have Delaware corporations on the other side. So no diversity, and the settlement happened that night.
So
And they filed or at least the dismissal motion got filed that night, and the settlement happened later, I believe.
So just to close the loop on this, because I think you're both hearing that we're kind of stuck on this case and controversy issue, and this relates to Justice Morgan's earlier question. You would argue that given the provision of Section 9 allowing any party to file an application for confirmation, and there was at least an arbitration amongst all of the parties, that would either in effect substitute or replace the case and controversy requirement, or are you saying the case and controversy requirement was satisfied because there was active litigation and arbitration among all parties, even though there was no adversity as we come to understand it as litigants?
Right, we made that allegation in our original petition where we said, under the FAA, a party seeking to confirm an arbitration award continues to have a live stake in the proceeding, and thus it has standing to seek confirmation. And so there was no special exception to our pleading, so you can liberally interpret it. And we said it again on the next page. Standing also lies under the TAA entitling plaintiffs to seek to enforce the arbitration agreement and confirm the award as to POOLRE. There's nothing contingent or hypothetical about a request to enforce the arbitration provision and confirm the arbitration award in order to bind POOLRE. That's the Thomas versus Cook case
Right.
out of the 14th. So we were going off of the UPS case and Thomas versus Cook, viewing the right to obtain a judgment confirming the award as something that is a live case or controversy. And we stand by that, and I understand that there is a difference between statutory standing,
Right.
as conferred, if you create a class of people who can bring an action and you fit within that, that's fine. You've satisfied that. And then there still can be a constitutional standing requirement. But like I said, that attaches at the outset of the case where you have to have an entry in fact that the court is going to redress. And here we've already gone through all that.
Yeah, your point is this is just a summary proceeding, like the tail end
Correct.
of the arbitration process, all you're doing is just closing the end of that procedure. So it's not a new procedure where we have to reanalyze constitutional standing all over again.
Right, we're not relitigating any aspect of the arbitration.
Right.
It's dead and gone. And if you all don't have any other questions,
Do you have any-
I'll take my seat.
Justice Moore?
No.
Thank you.
Thank you, Mr. Gorman. Appreciate your argument. Mr. Foster.
Happy to answer any questions, but I have a few things to say. So there was some statement that I just heard that said, we, as in the appellees, have money in the pool. We have a vested interest in the outcome of this case. That is categorically not true. This entity, Amy, that you heard him mention, did put money into the pool, was a party to the arbitration, but is not before the court today. It is an entity that is related to his clients in some fashion, but if they think, this is the basic point, if they think that POOLRE's post-arbitration conduct was improper, which we obviously dispute, and they can find a cause of action that some entity that they control can bring, they're welcome to bring it and we'll have a new lawsuit, right?
Well, but then, okay, to your point then those claims remain, they can file a lawsuit. But again, going back to this issue of the confirmation, they're not trying to enforce the judgment, they're not trying to sue POOLRE. They're just trying to confirm an arbitration award. To his point, this is the tail end, this is just a summary proceeding, nobody's litigating any of these issues.
Subject matter jurisdiction exists at every single phase of the case.
Sure.
It cannot be waived because it impacts the court's fundamental powers, right? So whether there was, I mean, it's quite common, that's the whole doctrine of mootness, right? I start with a live controversy with my opponent, and then at some point along the way in the litigation, at any point, I no longer have a live controversy with them, and then the issue's moot, and then the case is over. And so this idea that we don't need to look again at whether there's a case in controversy at the end of the process, I just think is completely
Well, I think most cases would say that when you look at standing, you look at the beginning of the litigation, right? At the outset, is there standing? You can't lose it throughout, right? You look at when the litigation first began. Numerous cases will say that's when you look at standing, and not after.
So I think that at any point in time along the path of a case that you lose standing and you can't proceed. I think it's typically at the beginning, of course, right? You file a lawsuit, the other side challenges it for lack of standing. It normally happens at the outset, but it runs through the life of the whole case. Critically here.
Is your argument then more of, I think there's so many issues here. There's standing, there's mootness, there's rightness, right? So standing just in terms of separate it out, because then I'm really understanding your question more as the mootness. At some point you can cease to have a case or controversy. So I see that more as a mootness issue.
So I think the primary issue here is standing, because as I've said a bunch of times, they just don't have a cause of action against my clients, and they never have. And that's a standing problem. They can't articulate what their claim is. Breach of contract, breach of fiduciary duty, whatever. They can't articulate what it is. That's why they don't have an injury, because none of the appellees in this case meet the definition of somebody who has money in the pool. So I think.
But that's more viability, right? They don't have a viable claim. That's different from whether they have standing to me.
Well, whether you have standing is whether you have an injury in fact that the law gives you an avenue to recover.
Right.
I mean, that's the whole thing. And the avenue to recover part is like, what's your cause of action? I can be interested in the outcome of all kinds of cases for whatever reason in a way that the law is not going to give me standing to intervene in the case. But I think to your point, I think mootness and rightness are the doctrines that courts will most often have crop up in the middle of litigation. Something happens and now the case is moot. But it's true for all of it. The subject matter jurisdiction is analyzed at every point along the way, not just at the front end. And what I want to say is at the front end, this issue couldn't have existed because at the front end, Feldman obviously had claims against the St. Charles parties. So he had standing to bring those claims against the St. Charles parties, and the St. Charles party had standing to bring the claims against Feldman. Nobody ever asked the question, does Feldman have standing to bring a claim against POOLRE? Because Feldman never tried to do it. And so there never would have been an opportunity for that question to even be asked because we were allied litigants.
I want to ask you one question before I forget that I had written down for myself. Is the interest in having res judicata effect of the confirmation award reasoning enough that there is some sort of case in controversy? In other words, the Feldmans are entitled to get confirmation so that they can have res judicata application of that judgment in the future. Why is that now? Why is that not reason enough for the court to confirm the award? Why is that? A better asked question is, why does that not make it a live controversy? They still have an interest in seeking that res judicata effect.
So I don't mean to fight the hypothetical of your question, but I don't think
please fight it if it's
okay.
wrong, because I want to make sure that this is your opportunity.
Yeah.
We're thinking of this in a wrong way. I want to get your input on that.
Res judicata adheres to the parties in the case,
right,
and the dispute between the parties in the case, right? The thing that we heard counsel complain about that POOLRE did was make this post-arbitration payment to its lawyers, right? That is necessarily something that was not considered by the arbitrator, necessarily something that's not encompassed by the award, because it hadn't even happened yet when the award issued. But again, to try to answer your question directly, res judicata is between the parties of the case. There's not a subsequent legal dispute that this party has that they've ever been able to articulate. It's like the Teamsters case, right? The Teamsters can say with great credibility, well, UPS has already violated this injunction once. Our injunction that we have the right to enforce, they might do that again. There's no setup like that here because, as I've said a million times today already, right? It's just not their declaratory relief. So the declaratory relief says what? That it's been adjudicated that the doctors have the right, have a declaratory judgment in their favor, the St. Charles Party have a declaratory judgment in their favor to have a declaratory judgment against POOLRE that POOLRE can't use certain pots of money for certain purposes. That is their personal right. They are the only parties that have the ability in any context to enforce that judgment or to do anything.
Right, okay. Do you have any further questions? Justice Morgan?
No.
Okay. Thank you very much, Mr. Foster. Thank you to both of the parties for your briefing and for your excellent argument. This case is now submitted and we are now adjourned.
All rise.